Good afternoon, everyone. We're going to start panel 3 on responsible disengagement. That is another topic that has been briefly mentioned in the previous panel. I'm Laura Iñigo Álvarez. I'm a lecturer and postdoctoral researcher at the NOVA School of Law. I'm also coordinating with Claire Bright, the NOVA Center on Business, Human Rights and the Environment. And I'm really happy to share this panel with esteemed colleagues and friends. We will have 5 speakers, well, our keynote speaker and other 4 speakers. I have to say that we will have small change in the program because there is another speaker, Cannelle, that is just arriving. So she will maybe talk at the end. But the topic we are discussing, responsible disengagements, and it was mentioned before that companies operating in conflict-affected areas or in high-risk scenarios might need to weigh the decision to stay or to leave in considering different adverse human rights impacts of whether staying or leaving. And this is part of what we call human rights due diligence, so this is not an isolated mechanism, but it's integrated as part of human rights due diligence. And without further ado, I want to introduce our keynote speaker, Sinisa Milatovic. And he's an expert on business and human rights, and is currently serving as a business and human rights specialist within UNDP. He's responsible for developing global programming and providing expertise on business and human rights to colleagues and partners in Africa, the Middle East, Asia, Latin America, and Eastern Europe and Central Asia. So to give us a bit of an overview of what responsible disengagement means, we will have Sinisa, so the floor is yours.
Thank you. Hi, everyone. I hope you had a good lunch. First, I'd like to thank Claire, Laura, and everybody here at the NOVA Center. It's really nice to meet you finally in person after all these sort of months and years of collaborating, and for inviting me to this great occasion and great venue. I guess the downside of it is that I was given the slot right after lunch, so I'll have to do my best. I also have to say one thing. I normally have a PowerPoint ready for this kind of thing. No. That's actually okay. But everybody in the last panel on technology had a PowerPoint, and I've decided to rebel against that. So you'll have to bear with me and listen to an old-fashioned speech, actually. It's my pleasure here to be here to talk about responsible disengagement. And obviously, it's a topic that's received a lot of attention recently in the media, in the public. There isn't a month that goes by in the news that we don't hear about a company that's been either called on to disengage from a conflict-affected zone, especially with the Russia-Ukraine conflict going on, or that has, in fact, disengaged from a conflict-affected zone. And for those of you that are following, earlier this month, Heineken announced it was completing its exit in Russia. It originally announced its exit in March last year after the full-scale invasion broke out. And finally, a couple of weeks ago, it announced that it's selling its 7 breweries and all its operations in Russia for a total of €1 to a Russian-led consortium, and that it would take a loss of €300 million in doing so. Now, obviously, a loss of €300 million to Heineken isn't a make or break thing, but I mean, it shows what kinds of serious consequences responsible disengagement can have. This was apparently the result of a long process because Heineken, as I said, first announced it was leaving Russia in March last year. It took 18 months to negotiate the sale. And as part of this, the buyer has an obligation to guarantee the jobs of local staff, of Heineken's local staff, for the next 3 years. And its CEO said that the process took so long because of so-called complexity. So while we don't know the details of how this decision was taken or what this complexity entails, the example shows that there are a number of considerations that a company should take into account before exiting or disengaging from a particular context. So the first question is, when might we disengage? And here, I'll just touch upon, because I know some other panelists will talk about this in more detail. a recent note published by our sister agency, ECCHR, the Office of the High Commissioner on Human Rights, which talks about businesses responsibly disengaging from what they call challenging contexts. And these are three, and then I'll focus on the first one. The first one is when the human rights situation is particularly grave, such as in conflict-affected areas, and Laura mentioned conflict-affected areas just now. Second is where national laws or regulations require actions that would be inconsistent with internationally recognized human rights standards. So this could be where a business enterprise is subject to employment laws that require it to discriminate against a particular group, ethnic or gender or sexual orientation and so on. And third is where national laws or regulations offer a level of human rights protection that falls short of internationally recognized human rights standards. So these are essentially states that are failing, where governance is not quite at the level it should be, and so on. But we will focus on the first one, so these conflict-affected areas that we mentioned, and on the possibilities that companies can responsibly disengage there. And I want to just show that responsible disengagement doesn't just occur in a vacuum, or it shouldn't occur in a vacuum. So even though you hear in the newspapers about a company leaving or being called on to leave a particular conflict-affected context, that decision to leave or to stay, to continue, to go, should be a part of a process that the company has been undertaking much before that. So it's part of a continuum. And this process we call heightened human rights due diligence. And I'll just talk a bit about what this means. So what is it? Well, if you're here, I'm assuming you know what human rights due diligence is, and we heard the panel this morning and so on. Heightened human rights due diligence differs essentially because it requires the company to identify its potential and actual impacts that it's having not only on human rights in a particular context, but also on the conflict. So how is it impacting what we call the context, so the conflict itself? And we hear, examples of this abound. The most notorious ones are where companies hire private security companies to, watch, over their operations and these private security companies commit atrocities, massacres, and so on. You hear of Lafarge, the French cement group, which was recently asked kindly by the US government to pay a $778 million fine because it was paying off the Islamic State in Syria to secure its cement plant. And at the same time, it's on trial in France. Its leadership is on trial for crimes against humanity. So these are examples, where obviously these are very, very, serious allegations and so on. Not all impacts of a company are as serious on a conflict, but we see companies that have impacts on conflicts because of the way they source. We heard this morning about cobalt mining and so on, and other examples. So the examples abound. So heightened human rights due diligence requires you to consider your impact and to mitigate it, not just to consider it, not only on human rights, but also on the conflict itself. So why should you do it? Well, to come back to the UN guiding principles that we've been talking about all day, they're built around the concept of proportionality. So essentially, the higher the risk, the more complex the process is required of you as a company. And the UN Working Group itself, the UN Working Group on Business and Human Rights, said because the risk of gross human rights abuses is heightened in conflict-affected areas, therefore action and due diligence by companies should also be heightened. And by the way, this isn't a new point that I'm making or the UN Working Group is making, but clearly one extremely important area of distinction is that in conflict-affected areas, where Geneva Conventions and international humanitarian law applies, companies are required to obviously respect it. So when should you do it? When should you carry out this heightened human rights due diligence? What is it? When should you do it? Well, first of all, clearly if there are armed conflicts going on, such as the Russia-Ukraine one, the classic sort of international armed conflict, or internal armed conflicts going on, civil wars and so on. But beyond that, if there are situations which are slightly less, let's say, that are slightly less obvious, if there's a military occupation, if there are gross human rights violations taking place, but also if there are any what we call early warning signs of the above. So we talk about early warning signs of a conflict breaking out. Those of you that follow this know that conflicts are sort of dynamic. They escalate, then they wane, and so on. So the early warning signs could include if certain groups are amassing weapons, if there are records of serious violations of international human rights law, if there is increased hate speech, rhetoric, and so on. And I always like to say, I come from the former Yugoslavia. All of these early warning signs were there before the conflicts in my former country, let's say, broke out. And you see these all the time. And in a guide that we published on heightened human rights due diligence, when I say we, I mean the UNDP and the UN Working Group, which I'll tell you about in a second, we tried to sum it up in a kind of a pithy catchphrase, which isn't particularly, unfortunately, effective, but we said, if in doubt, carry it out. Sorry for the bad rhyme. So the idea is simply, if it looks like a conflict could break out, you should be carrying out heightened human rights due diligence. You should be, as a company, thinking about your impact on the conflict, your potential or actual impact. So what is heightened human rights due diligence, to sort of stop beating around the bush? Well, essentially, as we said, it requires you not to just to sort of consider your impacts on human rights, so not just to carry out your human rights impact assessment, not just to integrate that into your operations, but also to do the same when it comes to the conflict. So that requires you to carry out a conflict analysis. There are tools out there that are available, including in our guide, to think about the impacts you might be having, to understand the interaction between your business and the conflict itself, and then to use this understanding to avoid negative impacts. Obviously, I'm not going to go into great detail as to how to do this, but I'll be happy to answer questions, and our guide is available. So this brings us to responsible disengagement. Okay, you've done this heightened human rights due diligence, you're in a conflict-affected area. What next? Should you disengage? Should you get out of a particular country if you're a company? The definitive answer is maybe. You should bear in mind that the UN guiding principles don't necessarily suggest that there's parts of the world that should be out of bounds for companies. They don't say if a conflict breaks out, businesses should pull out. First of all, because the UN guiding principles obviously apply to all businesses, including local ones. So that sort of advice would be misplaced. And second, because it doesn't necessarily follow that a company in a conflict-affected area is having a negative impact. So the UN guiding principles, instead, they provide a kind of a framework for you to assess as a company how you should address any negative impacts you're having on the conflict or on human rights. And the conclusion of the exercise, of this heightened human rights due diligence exercise, can lead you to the decision not to engage, not to relocate, not to suspend or terminate your activities. For situations when activities have started, the guiding principles refer to disengagement as an option for addressing negative human rights impacts of a business relationship, but don't deal necessarily with this situation. So I'm not going to give you a direct answer, a definitive answer on whether a company should responsibly disengage, but I want to note a couple of key considerations. First, that if you pull out too quickly as a company, if you carry out a hasty exit, that can be very damaging. It can be as damaging as an exit that comes too late, and we see examples of this. So the upshot of this is that if you want to engage in a conflict-affected area, you need a proper exit strategy. Second, if as a business you're contemplating whether to exit or suspend your operations, you should consider whether exiting and suspending could exacerbate tensions, and second, whether this would harm people and the harms would outweigh the benefits. So it's sort of a calculation on your part as a company. So what is a proper exit strategy? I touched upon this. Well, again, we note this in the guide a bit, but just to have a few points here, you should anticipate, you should have a clear exit strategy in advance. Ideally, at the same time you start an activity. We like to compare this to when you're a company, you have these act of God clauses, so you prepare yourself for the worst possible eventuality as a company, right? You have these contract provisions, if this happens, then that, and so on. What is to stop you from having the same when it comes to operating in a conflict-affected area? Effectively nothing. Second, you should consider whether exiting can exacerbate tensions within a particular community, population, and so on. Third, developing mitigation strategies. These could include giving reasonable notice to communities. At the same time, reasonable notice, we've seen in some examples where notice was given in advance, like Telenor in Myanmar gave notice in advance, and the state in Myanmar, the government used this notice to essentially capture its servers and so on. So you have to be very careful. These are not the same practices that you use in normal human rights due diligence. It's not always about communicating openly with the public and with your stakeholders and shareholders and so on. You have to be much more careful because the risks are much higher. And then finally, when transferring ownership, you have to think about the human rights capacities of the buyer. The Heineken example, just to come back to it, I don't know about the human rights capacities of the Russian group that bought, the Heineken breweries and so on. But the fact that a deal was agreed that local staff get to keep their jobs for 3 years is at least an indication, a positive sign that some sort of obligation was introduced. So I'd just like to add a couple more things and to end on where to next. Well, where to next? So this is obviously an important emerging topic, and I'd like to point to 3 trends. First, there's likely to be more regulation. All day we've talked about the Corporate Sustainability Due Diligence Directive, and in fact, the European Parliament's position introduces an obligation to carry out heightened human rights due diligence. And we have the fortune, at least so far, refers to the UNDP, UN Working Group Guide, as the reference point or a reference point. We'll see whether that makes it into the final text of the directive, but it shows the likely shift towards more regulation, just like we've seen more regulation of human rights due diligence, so we'll see more regulation of companies in conflict-affected areas. Second, there's likely to be more policy and guidance. Céline is here. She worked for BSR. BSR came out, Business Social Responsibility, came out with its own guide for companies in conflict-affected areas in our, let's say, following in the footsteps of UNDP and the working group. You see now guides for tech companies, for extractive companies, for others. So companies want to know more. They get in touch with us. They ask, what should we do? Should we pull out? In fact, I had governments calling me when the war in Ukraine broke out and saying, what do we advise our companies? Tell us what to tell them, should they pull out? And I said, well, hold on, it's not that simple. But essentially, people want to know more because of the third trend, which is that the legal and operational risks are huge. So I told you about Lafarge being ordered to pay $778 million. 2 weeks ago, in another example, Lundin Energy, which is a Swedish company, its CEO and another high-ranking official started of its CEO and another high-ranking official. They're standing trial for crimes against humanity for their role in crimes against humanity committed in Sudan. So those are the legal risks. The operational risks, I recently saw research in Finland that 2/3 of consumers are proposing to boycott companies that are still operating in Russia after the war started. So all of this just to say that this issue, I'm glad we're having this panel today because this issue is picking up steam. There's a need for more guidance, more thinking, more nuance, because especially on responsible disengagement, it's not as clear always as saying stay in or get out. And I really look forward to hearing what my fellow panelists have to say. Thank you.
Thanks so much, Sinisa, for giving us this overview on responsible disengagement, as you mentioned, as part of heightened human rights due diligence. And also, you also mentioned the guide that was made by UNDP together with the UN Working Group. And I think this is a very good document that should be taken also into consideration for further regulatory developments. Which also takes me to our next speaker, that is Leonard Feld, who is an advisor on human rights, business and tech at the Danish Institute for Human Rights. Welcome, Leonard, and he's gonna talk a bit more about those international standards and evolving EU law in relation to this issue of responsible disengagement. So please, the floor is yours, Leonard.
Yes, good afternoon, everyone. Thank you, Lara, for the introduction. Thank you, Claire, for the invitation. It's a pleasure to speak today. The topic is highly... the PowerPoint slides. Is highly topical, and I think I have actually good follow-up on the... Sorry?
Feld?
Yes, Feld.
Sorry.
No worries. Perfect, thanks. A good follow-up on the presentation by the keynote speaker, Sinisa. Thank you for that, because you elaborated on the role of heightened human rights diligence, whereas I will focus a bit more on what the international standards and then the evolving directive will say about, let's say, conventional disengagement in human rights diligence context, because I think it's something that must be generally differentiated, because you have the decision on whether to exit an entire market and country on the one hand, due to a conflict or to different political developments such as coup d'etat, etc. Or you have the very individual decision of exiting a specific business relationship that can happen on a day-to-day basis. Of course, they are interlinked. Of course, the process has some similarities, but I think in general, also the guidances, as we just heard, they are like more general guidance on human rights due diligence that also involves responsible disengagement, and the more conflict or difficult circumstances evolving guidance that is more specialized on that specific context. And with this differentiation, let's start into this term, responsible disengagement. I added here a slash to kind of show that it's a lot about engagement and very little about disengagement, at least in theory. And it is a core element of every human rights and environmental diligence process, and has a main objective of kind of addressing or preventing cut-and-run exits. So the exit of a specific context by a company without consideration or due consideration to any human rights impacts. And this can typically revolve in a classic business context, either in response to a human rights impact, that a company may have identified a human rights impact and then may consider exiting, or it may be different circumstances, and we saw it during the COVID pandemic, that the company may decide to exit or leave a specific supply chain for other reasons, but then due consideration should be given to the consequences of that decision, also with respect to human rights. And this decision to be taken is basically involving different dimensions, which I think are just interesting to reflect on, because they are kind of underlying this core factors we're going to speak about in the next slide. So there's a legal dimension that's very strong, of course. There are contractual provisions applying. There's national law context that kind of determines what is possible, what not, etc. There are moral dimensions here, because you may have to balance, as you said rightly, different interests, different rights at stake, especially when the decision to leave may also cause human rights impacts. So here it's a kind of a moral dimension to it. And finally, there is also, of course, a business dimension. Companies may be dependent on a specific business partner. There are also some reputational and financial risks involved. And all these different dimensions are kind of intertwined and are taken into consideration in the context of this decision. So what do international standards, so mainly the guiding principles, but also the work of the OECD, including the latest revision of the guidelines, say about responsible disengagement? Well, first, plan ahead. We already noticed that, already talked about that before. So proactive communication, expectation setting, and also contractual clauses that kind of foresee potential impacts, ensuring that the company has the leverage it may need in case an impact arises to affect change. Also setting clearly the expectation that the company will stay engaged as long as it's possible, while also maybe defining some red lines when the company may actually consider what to do next, whether it's a suspension or a disengagement. This is things to consider before entering a new business relationship, which I think is good to differentiate. When you're already inside a business relationship, the priority should be given to engagement, especially using and increasing leverage to drive change in the business relationship. However, if that is proving unfeasible, either because the measures do not prove successful or there is no prospect of success in a reasonable time, then you have to come to this kind of consideration, this kind of black box of making a decision. And in principle, companies here have a margin of appreciation, a margin of discretion on how to kind of come to one of the options available. But as we heard already by Sinisa, there are some factors that they have to take into considerations. And sorry for repeating, but I think they're worth to be repeated. It is kind of what impacts are at play, either options that may be taken, so impacts already evolving or impacts resulting from disengagement. What is the severity and the irreparability of these impacts? What is the prospect of driving change within reasonable time? Maybe this reasonable time may be a long-term time frame, especially when there are some systemic issues at play. It may be something that can be changed in a medium time or short time. That also depends on the specific context. What are the stakeholders saying? What are experts saying? These are often very difficult context and decision-making circumstances, so it's key, and the guiding principles emphasize that companies should get external input, of course engage with relevant stakeholders to seek all the opinions on the matter. And also there's consideration given to how crucial a business relationship is in a specific case. And this also links to the questions raised before. If you leave a business relationship, who steps in next? And what would be the consequences? Who would benefit from you stepping out, and someone else would take over your market share? And once companies have taken these factors reasonably into account, they have different options, which are all now reflected in the evolving EU directive. And there is first staying engaged, which is kind of linking to the general priority, while still taking mitigative and preventive actions. Then there is what I call disengagement light, which is that the company is announcing not to renew existing contracts in the future and not to enter into new business relationships with the same business partners in the future. And then there is temporary suspension, which is kind of a step before termination of kind of demanding specific results in a reasonable time frame. And then ultimately there is termination as a last resort means. And all these different factors and dynamics can also be kind of traced or can kind of be identified in the evolving CSDDD directive. So on first sight, one may say the different provisions by the Parliament, the Council, and the Commission are largely similar. They all have like a clause on disengagement light and on temporary suspension and termination. You mentioned already some core differences that the heightened human rights diligence finds only mentioned in the Parliament's text, but there are also some more little, I call it the devil is in the details, differences between the different proposals, which are generally trying to kind of define and also determine how this margin of appreciation or discretion that companies have should be defined. To what extent should there be strict rules that companies have to follow? To some extent, to what extent should companies given like some discretion to decide on a case-by-case basis? And there's general agreement that the severity of the impact should be definitely a decisive factor on the decision whether to terminate. So the severe impacts may lead to termination. On the other hand, there are some minor discrepancies on what role or what emphasis should be given to this exit strategy, because there are also concerns, especially on the Parliament side, that companies may take an exit as an easy solution to a complex problem. So we see in the different proposals, for example, on the disengagement light clause, that the Council added the term last resort, so emphasizing that also the disengagement light should be a means of last resort. The Parliament it goes in a similar direction by limiting this option or this kind of obligation to cases where companies are actually causing or contributing to a specific impact. Also here, further limiting the scale of this particular provision. And similar differences emerged in relation to temporary suspension and termination, which is principally companies are obliged to do if the measures they take prove inadequate. And there's no prospect of reasonable change in the near future. And here, most notable change is that the Council proposes an exception that companies are not obliged to disengage when they don't have a reasonable alternative. So if this particular business relationship is essential for their business operations, when there is no reasonable alternative and there's sufficient prejudice to their own business. And similarly, the Council, setting aside the general topic of financial sector inclusion, is proposing that financial institutions should not be obliged at all to disengage, given the circumstances of this particular industry, they claim. And the Parliament, in turn, makes different changes, proposing first that more emphasis should be given on the process that companies have to take, so that companies should actually have this process in place, should assess the impacts of engagement and disengagement, and should then, based on this particular process, come to an informed and due process-based decision. They also mentioned particularly, which is also international standards, that companies, when they decide to disengage, they should also take measures to address the impacts that may result from disengagement. So this is like explicitly mentioned in the Parliament's proposal. And similar to what you already have said, that the Parliament also proposes that companies have to give due notice and that they also have to reassess a decision depending on the evolving circumstances in the specific context. And with this, some key issues looking forward that I felt like worth emphasizing. Of course, we don't know what the final text looks like, but what is generally important to emphasize is that it should be ensured that the companies eventually take a risk-based approach, not a compliance or tick box exercise that allows for this nuanced decisions, because defining strict rules for this very complex decision-making process is difficult or near to impossible. So there should be clear definitions of factors that companies have to engage. There should be due process to ensure that companies do engage with these different factors before taking a decision. And moreover, there is also a need for what we call like accompanying measures. Because if companies at large scale demand from their suppliers in the context of business related human rights impacts to kind of change their business behavior to address impacts, but certain smallholders, especially in third countries, have not have the capacity to address this in a short time, especially when there might be some systemic root causes to this, then it is important that the EU is not only defining legal rules on this, but there should also be accompanying measures through development policy or different funding, etc., that kind of ensure that these smallholders are put in the position where they can actually meet the demands that this directive is also furthering through global value chains. And these were a few reflections, and I'm happy to discuss further. And now I give the floor to my more practical-oriented co-panelists. Thank you.
Thank you, Leonard, for bringing the regulatory aspect. What's the directive, the draft directive is looking like regarding disengagement. And we will have now the perspective from Professor Miguel Ferreira, who is BPI Fundação Caixa Chair Professor of Responsible Finance at NOVA School of Business and Economics. He's also Vice Dean of the same faculty and the Academic Director of the NOVA Finance Knowledge Center, and he will bring the perspective of investment and investment decisions. So whenever you want, Miguel, the floor is yours.
Good afternoon. Let me first thank the organizers for the invitation, especially to Alison that came to my office asking me to participate in this panel. At first, I didn't realize this was a poison pill because I'm in this panel, or I think in the conference, I'm an outsider, but I try to bring some insights from the investor's perspective that could be potentially interesting for everyone. So I'm going to take the point of view of institutional investors. The reason for this is because institutional investors has been one of the main topics of my research agenda, in particular trying to understand the effects of foreign institutional investors on companies' policies and performance. And the main idea, the evidence showed that foreign investors are not necessarily bad guys. They have an independent status relative to domestic stakeholders, and they, in many times, they use that independent status to improve company policies, investment policies, innovation policies, to create more jobs and improve company performance. So when I talk about institutional investors, I'm talking about what? I'm talking about money managers, mutual funds, and here it's worth to mention the big three, which are BlackRock, Vanguard, and State Street. They hold more than 20% of the world market capitalization, so they are very important players in capital markets worldwide. This large concentration has its own problems. It also has some advantages. But basically, these big three money managers, they rose because of the increase in passive investment in ETFs that you may have heard about, which is a good way for retail investors to invest their savings. I'm also talking about pension funds, sovereign wealth funds, as the Norge Bank Investment Management I'm going to mention a couple times during my presentation, because they are a good case study. And also endowments like Harvard or the Gulbenkian Foundation endowment. And these institutional investors are main shareholders of companies worldwide. So in the US, they hold more than 70% of the companies, of the market capitalization. But even outside of the US, they own almost 50% of the market capitalization. So these institutional investors are an important market force. And actually, in my research agenda, we show that this market force played by institutional investors, it's many times more effective than regulation in promoting change. For example, good changes in corporate governance, in general in corporate social responsibility. And because they are main shareholders of companies, they can influence the company investment policies and performance in which they invest. And they can influence directly the companies where they invest, but they can also influence indirectly other companies, because the companies where they invest, they have relationships with other companies, because they are clients or suppliers, or because of the ultimate owners of these companies. And just to give an example, like the Saudi Arabia Public Investment Fund, they are main holders of many companies such as Lucid, that produce electric cars, or Uber. And we may be worried about who are the ultimate owners of some of these companies. So they can influence directly the companies where they invest, but also indirectly through the relationships that these companies have with others. So what are the strategies followed by these institutional investors when they invest in equities as shareholders? And the figure shows how frequent PRI signatories, PRI, it's the Principles of Responsible Investment, that is signed by many institutional investors. And you can see there's a range of strategies they follow. Some are more frequent than others. So the first decision is which companies to buy, which companies to invest in, and it's very frequent here that they use negative screening. So they exclude some sectors like sin stocks, tobacco, arms, oil and gas has also become a sector which is many times excluded. You may have seen in the news recently that the English church decided not to invest more in oil and gas. Or the Norge Bank also does not invest in oil and gas. And this is a very frequent strategy followed by institutional investors. They may also exclude countries for civil rights reasons or because of armed conflicts, such as the Russian invasion of Ukraine, or due to the military coup in Myanmar, or even going back further, but it's also an interesting case study due to the apartheid regime in the 80s in South Africa. They may also employ positive screening, not as frequent as negative screening, which means you invest in all sectors or almost all sectors, but you try to invest in the best ESG firms in a given sector. So if you want to invest in mining, you're not going to invest in Vale. You're going to invest, for example, in Anglo-American, which is better ESG practice. There's also thematic investing, which is not as frequent, where you're going to allocate capital to certain goals, like social investments or renewable energies. And at the middle, which is a strategy that is employed by almost all institutional investors, it's what we call integration. So you're going to integrate ESG factors in all the investment process, from research to portfolio selection. And then you have engagements. There are several different types of engagement, from individual to collaborative. Collaborative engagement, it's typically very effective. And also voting, proxy voting. And here it's very important that it should be internal. It should not outsource, this institutional investor should not outsource this proxy voting to proxy advisors. It's important that institutional investors do their own due diligence when they exercise this proxy voting, and they can influence by approving or rejecting some of the proposals of the management of the company. So engagement is a very important strategy, and I'll mention as a potential solution to the dilemmas of responsible disinvestment. Engagement is many times also referred as active ownership or stewardship, and it's a very important strategy that it's very frequently followed by institutional investors. And then at the extreme, if you are not happy, if anything else doesn't work, you can sell and disinvest. And just to give an example on how investors can have an influence and try to tackle some of the challenges like climate change. More than 70% of greenhouse gas emissions, it's done by just 100 firms, large firms, which have investors, institutional investors as shareholders, and they can play an important role in trying to reduce emissions and trying to mitigate the effects of climate change. So the big question is what? Is whether to engage or to divest. Or 20 years ago, you would not say engage or divest, you would say in finance or economics whether to voice or to exit. But it's basically the same question. Voice in the sense of talking to the management and trying to influence directly the management of the company. So to divest has some benefits, like drawing attention of society to human rights violations, like during the South African apartheid regime, or more recently the Go Fossil Free movement, 350 movement, and this can create and put pressure on policymakers to change. It can also affect stock prices, and this is important because if it affects stock prices, the cost of capital is going to be higher for bad ESG firms, for example, firms with that are high carbon emitters, as investors are going to require a risk premium to invest in these firms. Although so far the evidence is quite mixed in terms if these movements, these investment movements are actually able to influence stock prices. Although there's a very interesting recent study that shows that the 350 movement really depressed stock prices of high emitters of carbon. However, there's issues with this investing. Okay, so we have several evidence that it influences the social discourse, but it doesn't affect stock prices. Although there's this recent study with positive effects, and so it potentially has limited effects on cost of capital and the real investment policies of firms. And there's actually a paradox. And the paradox is if you're going to disinvest in a brown firm, the prices will go down, so the stock becomes cheaper for other investors to buy, and these other investors that are not green investors are actually going to earn higher returns. So there's a paradox here of disinvesting in bad ESG companies or brown companies. And there are several collateral damages that have already been mentioned here. If you disinvest, especially in developing countries, there's going to be negative economic effects for the more vulnerable populations, like job losses, income drops, and ultimately hunger and poverty. If you need to sell, like in Russia, you're going to sell at a fire sale price, like in the Heineken case. And this is going to actually benefit the regime. And it's going to transfer wealth from a company that's probably better in terms of ESG to another investor, to another shareholder that it's going to be probably worse in terms of ESG practices.
Sorry, Miguel.
Yeah, I have to finish. Yes, sorry. And just to conclude, so what's the solution? The solution is to engage. As we mentioned here, we have robust empirical evidence showing that engagement is successful in terms of stock outperformance, in terms of real effects of the company changing its investment policy for the better. Collective engagements are particularly effective. So the solution is what we usually call in finance, at least, twin-track approach. So we employ exclusion only when engagement cannot be successful. And you divest as a last resource. And this is an approach that has been taken by more and more institutional investors around the world. Thank you.
Thank you, Miguel. And indeed, I think it's key to understand the role of investment and investor and how they can play a direct or indirect influence into decisions by companies. And now I'm gonna quickly move to the next speaker because of time constraints. And we will have now Cannelle Lavite, who is a French-trained lawyer and director of the Business and Human Rights Program at the Berlin-based European Center for Constitutional and Human Rights. And she will share her insights into mainly the Lafarge case that was already mentioned by Sinisa. So we are gonna move now more the practical side, the question of litigation, and later on we will continue with Céline as well, sharing some practical experiences.
Great. So for the interest of time, I will start. I don't need the PowerPoint right away. Apologize for my delay, also for my co-panelists for not listening to your input. And I'm glad that there was already a good theoretical background that was provided, because then I can go a bit into some practical considerations. So before I go into the Lafarge case, I wanted to explain also where my approach comes from. I work with the ECCHR, which is a human rights organization based in Berlin, and our work is to accompany individuals affected by grave human rights violations with legal means. And specifically in the Business and Human Rights Department, what we do is that we accompany workers or affected communities or individuals by corporate harm in their quest for justice, reparation. Most often they seek this before the courts where the headquarters of the companies involved in the corporate harm are located. I also wanted to say that looking at the cases that we've been working on with the CCHR, it's very, very rare that we actually get from the communities of people we work with the request to litigate a demand for a company to disengage. What they usually want is for the companies to stay in the respect of their rights, but they have not, as so far, we haven't had a request of someone that we're working with for a company to disengage. And it's also not something that we generally advise communities or individuals who reach out to us, simply because we don't feel like we are in the capacity to assess whether a decision to disengage would actually bear more costs on human rights than the status quo, with the hope that the status quo gets improved. I wanted to talk about the Lafarge case because, so the Lafarge case is pending before the French Supreme Court. And also as a disclaimer, this case comes from a criminal complaint that was filed by 11 Syrian former employees of Lafarge in Syria, but also ECCHR and Sherpa, our partner in France. So we are partie civile in this case. And although I'm aware that obviously the situation that I will now explain to you is very specific because it concerns responsible disengagement and decisions to stay or not in the context of armed conflict. And I'm also aware or hopeful that things have evolved since the facts of the Lafarge case, which took place between 2012 and 2015. But nevertheless, the amount of public information, or rather, no, the amount of internal information shared by the company, within the company, that was leaked, and this is how the case started, this information gives, I think, a very unique insight into how a multinational is thinking about its decision to stay or not in this kind of situation. And I think it's very illustrative, basically, of the gap between the theory that was explained by my co-panelist and the practice that we experience not only in the Lafarge case, but also in many other cases that we've been working on. So Before I go into the facts, give you a little snapshot of where the proceedings are at in French courts. So Lafarge, as a legal entity, is currently charged for complicity in crimes against humanity, endangerment of people's lives, namely its former employees, violation of an embargo, and financing of a terrorist enterprise. And 8 of its former corporate executives, both in the subsidiary in Syria and the headquarters in France, have been charged with endangerment of people's lives and of financing of terrorist enterprise as well. Last year, the US Department of Justice issued, or there was a plea agreement issued with Lafarge for an amount of this amount, $777 million, which is the highest settlement that was ever reached, in exchange of which Lafarge pleaded guilty for the financing of a terrorist enterprise. So what happened? Lafarge is a French multinational company and worldwide cement leader that merged with the Swiss cement leader now Holcim in 2015. And in 2007, Lafarge acquired the Jalabiyya cement plant, which was located in the northern part of Syria, at the cost of approximately 680 million, which was the largest investment in the country outside of the old sector. And it started running the plant in 2010. And in 2011, the conflict started in Syria and escalated extremely quickly to the point that in 2012, ISIS, or the Al-Nusra Front at the time, and then later ISIS, surrounded the factory. There were a lot of fights between ISIS and also the Kurdish army. Employees started to be kidnapped in 2012. Kidnappings and horrendous acts that were qualified by the French courts later as possible crimes against humanity were happening in very nearby to the factory, between 10, 20 kilometers and 90 kilometers. And at this point, all major multinationals operating on the country, such as Shell, Total, Schneider Electric, decided to leave. And Lafarge took the decision to stay, to remain operational. And by the end of 2013, they were not able, Lafarge, to continue operating in this region without making payments to several armed groups in the region, including ISIS. And the judicial inquiry revealed that up to 13.5 million euros were paid to armed groups and $500,000 to ISIS intermediaries. But this is only what has been uncovered, yes, by the judicial inquiry. It's not a final amount. So, as I said, in 2012, we have kidnappings of Lafarge employees starting. And the same year, Lafarge takes the decision to organize the evacuation of its expatriate international employees to Jordan and back to France, but leaves the employees, the Syrian local employees, in these conditions. In September 2014, ISIS launches a violent attack against the factory of Lafarge, takes the factory, take control of the factory, and will actually operate it for several months later. And during that attack, Lafarge's employees were left with no evacuation plan and left to flee on their own. These are the main facts. And I want to make a few remarks. One, giving you a little bit of an insight on the reasoning of Lafarge, which these quotes come from the DOJ plea agreement. So their investigation has been made public in some parts. And we can see from those emails that Lafarge executives, their motives are purely economic. They have not only paid taxes to ISIS in order to get their trucks, their cement, and their employees freely circulate in the area, but they have also entered into revenue-sharing agreements with ISIS, which incentivized ISIS to act in Lafarge's subsidiary interest. They have also sought ISIS's assistance to impose costs on the cement of competitors in order to undercut their prices. And what I found very interesting is this quote, where two reasons are given by the executives not to close the factory. One is that they don't want to take any risk with regards to the upcoming merger with Holcim. And second, they fear that if they disengage even provisionally, they will be looked at, they will be watched closely when they try to resume after the merger. Second remark, the price to pay was mostly for the employees. The employees, as I said, were subject to many risks, but they also voiced this to the company and asked the company not to come to the factory. They were forced to live in Membige. This was imposed by the company, by Lafarge. Membige was a city that was at some point under the control of ISIS and a very dangerous city to live in, and they had every day during their work commute go to pass through checkpoints that were checkpoints where ISIS and other armed groups were. And despite this voicing of the employees who said we cannot and we do not want to come to work, instead of this, Lafarge didn't take measures. They pressured its employees to come to work, threatening with dismissal if the employees would not do the commute every day to work. And the second cost is also a cost for the company, because as I just said, there was this plea deal agreement. And I finish. Do I have 1 more minute to finish? Yeah. What is important also to say is that the financing of the terrorist enterprise, it was later found by the appeals court in France that ISIS was at the time finding most of its revenue from taxes, but also from the selling of raw materials, which are the two activities through which Lafarge entered in agreements with them. And therefore, we can also say that the negative impacts that Lafarge may have contributed or caused were also impacts of the surrounding population that was exposed to the commission of crimes, including crimes against humanity by ISIS. And so we have made recommendations in order to take some lessons learned from this case, because we think that at this point, what Lafarge should have definitely identified as risks is the brutal stopping of the activity as it happened. Also the risk that the activity in the factory would then be taken over by armed groups, such as ISIS, but also the risk for its employees. And I think this is, as I said, this is very exemplary of the gap between concept and practice. But also, I think it shows that there is the responsible disengagement concept is not yet perceived by companies as something that they need to integrate very early on in their economic models. There is still a very tick-the-box exercise that we see also with human rights due diligence in general. And if we look at the Lafarge case, I think that we see one of the main challenges to non-tick-the-box exercise of human rights due diligence, and that is that Lafarge at the time didn't consider that human rights that apply to their employees in France and their obligation to respect human rights applied outside of France. And there is one quote on which I will finish. Is the quote where asked, executive director of Lafarge is asked how they can justify having financed ISIS in order to continue production. And they respond, well, one need to understand that at the time, ISIS hadn't done anything outside of Syria. There had not been any Charlie or Bataclan effect. This was a Syrian affair. I leave it at this. I think I'm already running out of time.
Thanks so much, Cannelle, for talking more about the Lafarge case, all the complexities. And I think this is the first case against a legal entity in terms of complicity in crimes against humanity. And also Sinisa mentioned the case that is in Sweden, but I think this was the first one, again, a legal entity. And of course, there are many lessons that we can learn from this case. Following with the practical insights, I want to invite my colleague and friend, Céline Graça Pires, who is a business and human rights specialist, external advisor at BSR and research associate at our center, the NOVA, the Knowledge Center on Business, Human Rights and the Environment. And she will share some lessons learned and the challenges also from her practical experience. So please, the floor is yours.
Thank you so much. I actually choose remain seated because I'm a bit sick. I just recover my voice, so if you don't mind, I'm happy here. So would you like my help for the PowerPoint?
No,
yeah.
No, it should be on.
Oh. Okay. Perfect. So it's just a few slides. Don't know if you can switch at distance or if no, I mean, thank you. Oh, perfect. Oh, yes. Okay, perfect. Okay, so preliminary considerations. So normally, as Sinisa mentioned, I normally talk about exit decision in conflict-affected areas and high-risk context. I work myself in Angola, Mozambique, Colombia, and Honduras more recently. But this time I have chosen to discuss a topic that we don't hear much about, which is disengagement process that led to the decision of staying responsibly engaged with a business relationship associated with adverse human rights impact. So I choose to start with these two images. First images, as I realize when you look online for responsible disengagement, we may come across this picture and similar ones where the go sign is green and the stay sign is red, which actually supports the external common perception that staying is a wrong decision and could lead to bad consequences, when we know that in practice, this is much a gray area. There is no unique solution. I never came across very easy, simple, binary cases. It's always about finding the right balance and a nuanced decision to stay or to go. So no universal solution for gray zone areas, I'm afraid, because they are highly context dependent. So after mentioning that, I would like to share with you a few lessons learned advising companies in their disengagement process, again, that led to the decision to stay engaged with a business relationship associated with adverse human rights impact. Independently, if this is a conflict-affected areas or high-risk context, is the business relationship associated with adverse human rights impact. So if we move to the next slide, yes. Just a few concepts, because I will use that concept. Leonard here already discussed those concepts. But when we go through disengagement decision-making process, there is a few factors that we need to take into account. The first is the concept of leverage. I'm quoting here the commentary of Guiding Principle 19, because there is sometimes this misunderstanding from companies in practice that think that the OECD guidelines or the UNDPs are actually calling for disengagement immediately when an adverse human rights impact arises from a business relationship, which we know it's not the case. What the OECD guidelines UNDP elaborates on is on the responsibility of a company to firstly engage with the business partner, use its leverage over its business relationship to address the adverse impact. If the company lacks leverage, find ways to increase its leverage, and then only consider ending the business relationship. So it's a concrete process flow, several phased, before leading to the conclusion to actually disengage from the business relationship. So the concept of leverage is really important. It can be defined as the ability to effect change in the wrongful practices of an entity that causes harm. Then the second concept I would like to cover is credible and independent assessment, because the decision to exit or the decision to remain engaged need to be built on a credible, independent assessment, meaning conducted by a human rights expert or a skilled expert with field experience, Why is important? Because we want to have the perception and the perspective of the directly affected stakeholder. And engagement in such tense context with affected stakeholder is very tricky. So we need skilled, experienced experts to conduct this credible and independent assessment. And then the last concept is crucial business relationship. Sinisa and Leonard already mentioned that, so very quickly, just want to flag that many decisions to stay engaged are actually linked to the fact that it's very challenging to end a relationship when this relationship is perceived, experienced in practice as crucial. So for the definition, if there is no common definition of crucial business relationship, but we can say that a relationship could be deemed as crucial if it's provide a product or service that is essential to the enterprise business or for which no reasonable alternative source exists. So for instance, we heard this morning from Anais the cobalt mining in the Republic Democratic of Congo. So there is not a few alternatives out there. The same is happening for some commodities that need particular weather circumstances like coffee, cocoa, or bananas that need to grow in specific environment. And in some of the countries, there are high-risk context. Same happen with minerals that we need, well, apart from cobalt, for low carbon transition. So we need to have this in mind when starting a decision-making process of exiting or staying engaged. And finally, this is not on the slide, but I would like to echo Cannelle presentation here. It's also about considering how crucial our business partner position, operation are in the area. Most communities I'm working with do not want the company to go because they are highly dependent on the company operation activities for their livelihoods. What they want to do, as Cannelle mentioned, is an evolution of the statu quo. So it's not about just staying. It's about staying responsibly. It's about non-business as usual. It has to be disruptive to be evolved. Yes. So 5 lessons learned from practice would like to cover. And hopefully I will have time. I hate to be the last one because I know the moderator is evilly looking at the time. But so lesson 1 is actually using the threat of disengagement as a powerful tool for change. I mentioned in previous slide the free resources and just mentioned to Joseph from SOMO that he could be sitting here because it's, should I stay or should I go? It's one of the most useful resource out there. So I know you cover also the threat of disengagement in that note, so I will definitely echo you on this one from practice. So in a case of the decision has been made to remain engaged with a business relationship associated with an adverse human rights impact, the threat of disengagement increases leverage over the business partner and accelerate the changes without having to completely disengage, but to be effective, credible, it needs to be materialized. It's not an overall threat. It's actually materialized, for example, through a suspension of commercial relationship, through the significant reduction of volumes, or to just a pause in terms of purchase orders, for instance. But it needs to be materialized. And then to echo Sinisa, yes, in practice we see, and it's definitely not perfect, a lot of room for improvement, but we see more and more companies interested in integrating into their contractual clauses relationship a phased approach to disengagement with the different phases. For like I've seen like clauses suspension for 6 to 9 months. Then we reassess, then possibly suspension number 2, and then disengagement. So that's something we have seen in practice, which is emerging. Lesson learned number 2, it's to be part of the solution and co-develop what we call SMART, corrective action plan. So normally, what the commentary of the guiding principle 19 says to us is that when you take the decision to remain engaged with a business relationship associated with an adverse human rights impact or environmental adverse impact, we need to publicly be able to disclose on our ongoing effort to mitigate the harm, which in practice cannot be effective if you leave the entire burden, financial, reputational, operational, to your business partner. It has to be a shared, co-developed, corrective action plan. So instead of thinking of disengage or just imposing your own condition, you need to think about investing additional resource to this business relationship so your business partner can effectively make progress in terms of addressing adverse human rights impact. And finally, SMART, corrective action plan. SMART stands for specific, measurable, agreed upon, realistic, and time-bound action plan, meaning specific timeline for the implementation of concrete, measurable action for each adverse impact identified. And then you have key milestones, because you can take the decision to stay, but it's not for life. So the room is, the door, I will say, is still open. So after a key milestone has been agreed, you can sit with your business partner, reassess the situation, and you will be, able to say, finally, after staying a few months, trying to support you to make progress, we will leave. In terms of action plan, my last point will be that as per alignment with the OECD guidelines and UNGPs, we need to see quick progress in terms of addressing adverse human rights impact when it comes to the severe human rights abuses. So the timeline to address severe human rights abuses, for that specific adverse impact, the timeline would be shorter. So what I've seen in practice is like the business partners have 3 months to 4 months to make solution and progress for sexual abuses, men or women, for forced displacement, violence committed by mine security. So that's the kind of severe abuse that need immediate, measurable, very short timeline. And then we reassess based on progress made if you stay or if we go. Lesson number 3, accept the consequences, but do not stay at all costs. Again, commentary to guiding principle 19, where business enterprise is connected to human rights abuse, the company needs to be able to demonstrate its own ongoing effort to mitigate, but also be prepared to accept the consequences, meaning reputational, financial, legal, but not at all cost. You need to be prepared to face the risk of legal claims, legal liability, so you need to be able to still conduct human rights due diligence, as Sinisa mentioned, specifically in conflict-affected area, to evidence the concrete step you are taking in support of your business partner to mitigate adverse impact. And finally, it's always time to leave, because there is a possible risk, because the situation is not static, the situation can evolve, and for the worst. So it's possible that when you will find, through assessment, that you may be accomplice of a gross human rights abuses, the exit door needs to be still open.
So we need to conclude.
I know. Lesson number 4, don't be afraid to communicate with a wide range of stakeholders very quickly. What we noticed is that companies are very reluctant to engage with civil society, NGOs, about concrete steps they are taking on the ground to mitigate and support business partners to address adverse impact, but not so well reluctant to engage with authorities and politicians. So what we are pushing in practice for is open discussion but taking into consideration confidentiality constraints and, of course, people's security concern. There is always safe space to discuss with NGOs through credible proxies, including human rights experts. And finally, my last point, I swear, as to use the case to move from reactive crisis management to proper crisis preparedness. There is, again, no one single scenario that could be duplicated for every single situation. So I often hear, oh, that was a very reactive approach to exiting. That was a very reactive approach of the Russian invasion. Yes, but I'm fine with that if upon the condition that this crisis management, not well prepared, will build and be used to build a crisis preparedness effective management for future. One concrete example, I invite you to see Telenor that completed its internal learning process after the companies decided to exit Myanmar. They've published the learning outcomes that actually inform their crisis preparedness strategy, including a responsible disengagement strategy with different steps. So that's it for me. Would like to leave the discussion with an open door. That's something I discussed with Sinisa during the break, which is forthcoming challenge. I know we are talking about conflicts, but what we are seeing in practice,
Sorry,
yes,
really
I'm opening the door because we have a very important case currently led by Portuguese youth about climate change. So would like to mention climate change here. What we are seeing in practice is more a disengagement decision, disinvestment decision due to climate change effects, which lead also to very difficult situation on the ground for vulnerable populations. So food for thought for upcoming discussion about responsible exit.
Thank you.
Thanks.
Thanks so much, Céline, for bringing all these lessons learned. Also about the decision to stay, the consequences. I think we all agree this should be a last resort, although it's not clear in the UN, it's not explicit on the UN guiding principles. And I also agree on the point that you mentioned, the importance of communicating with a wide range of stakeholders, whether to decide to stay or to leave. This is also a very important step. And I'm gonna move very fast to our youth ambassadors. So I will collect one question each, and then I will give the floor back to the speakers with the condition that you have very short answers. So
I will also try to be brief.
Yes.
Thank you for all your presentations. My question is for Sinisa and Céline. So in a conflict-affected area, when deciding on whether staying or leaving, we know that sometimes there are this barrier that is created to stakeholder and right holder engagement, not only because of the circumstances, of course, but also because of the fear for reprisals. And my question is, how can companies prioritize when engaging with relevant stakeholders in this specific context?
I'm gonna also collect a second question by Ricardo, and then I will give the floor back to the speakers.
Okay. Thank you for your presentations, were all very insightful. So Sinisa was saying about how the war in Ukraine and brought global attention regarding disengagement and how this was unprecedented. How can practitioners and policymakers take advantage of this momentum? And if this momentum is actually a double-edged sword, or what is your thought on this? Yeah.
So maybe we can start with Sinisa.
Sure. In the interest of brevity, maybe I'll answer the second one and then you answer the first one, and if I have any other thoughts. So how to take advantage of the momentum? I mean, I think taking advantage of the momentum means looking at more, as I said, concerted efforts to regulate this area. We talk all the time about the smart mix. Just like in other areas, in this area, the smart mix has been skewed too far on the voluntary end. And we've had now 12 years since the UNGPs. We have evidence that the smart mix necessarily hasn't brought the results that are desired, at least the way it's been interpreted. So I think we are all in agreement, broadly speaking, that there should be some sort of regulation of this area. What the content is a different matter. It is a double-edged sword in this case, I mean, the Russia-Ukraine example, because it's an unusual example, frankly. It's unusual in the sense that, you know, it's an international armed conflict, which we don't see too many examples of. It's in danger of obscuring some more typical examples of, you know, sourcing from conflict-affected areas, power asymmetries between companies and local communities and so on. These are more sort of typical examples that even our guide was directed at, to be honest. It doesn't mean that it's not applicable to others. So, you know, we shouldn't think just simply in terms of Heineken pulling out of Russia and so on. We should also think about, you know, your more typical example of an extractive company in a conflict-affected area, etc. And then finally, I think the thing that we really don't think about at all, which, because it's hard, is that, you know, we're always talking about multinational companies pulling out of certain areas, etc., etc. The guiding principles apply to all enterprises and all human rights. What about, you know, local companies? What are their duties? I mean, small and medium enterprises and so on. Obviously, they can't pull out, if that's the term you want to use. But what is disengagement in their sense? I mean, what does that mean if you're a local company? You know, how are you supposed to proceed and so on? I don't have an answer. I'm just telling you that it's not an easy question to sort of grapple with. Céline.
Thank you. It's working? Yeah. For the first question, no easy answers. I'm afraid that's a concrete and practical barrier in terms of engagement with right holders and conflict-affected areas and high-risk context. So a few thoughts on that, three exactly. One, I would like to say security first. Because for credible assessment, we definitely need the perception of right holders, but as you mentioned, fear of reprisal, so we need to find safe spaces, or at least if remote engagement, safe platforms to engage with them. So I had very bad experience with WhatsApp, for instance, in Colombia, more recently in some countries in Africa. So we try to reach out to Signal, or we want through journalists on the field to use them as point of contact to have their perception, because it's also very difficult to get trusted. So you need to find a way to ensure safe places for security first. Then second thought is that if not possible to engage directly with right holders, you need to use credible proxies. So human rights experts with an experience in human rights conflict affected areas could be a source and a point of contact to engage directly with NGOs, for instance, that will represent the interest of the right holders in the field. So it's kind of a domino effect to get the perception, but still remain valid in certain context. And the third TOF would be about multi-stakeholder initiatives, because I've been working with a few companies a bit reluctant to not say reluctant, to engage directly with right holders, which means also serious concern for credible assessment that will need to inform your decision to exit or stay. But in this particular situation, a solution we found was multi-stakeholder initiative, when you can hear from your peers who has the opportunity to engage with in the same operational areas, which is a very limited context, with right holders. So that multi-stakeholder initiatives are a good platform to hear about what is going on the field. It's kind of indirect source of information, but still a source of information. Definitely not perfect, need to be complemented with other sources, but important to mention. So with these three TOF, no perfect answer, I'm afraid, very context dependent, but at least a partial step for engagement.
Just some concluding remarks also by Leonard, Miguel, and Cannelle, or if you want also to reply to the questions.
Yes, maybe to the second question that was answered first. There has been some interesting report by Business for Ukraine. It's like an initiative of companies as well as academics that have kind of analyzed the exits of companies from the Russian context. And it's a quite interesting resource to take a look at, so maybe a food for thought on this particular challenge, because they also discussed with a specific agenda, specific issues like paying taxes to the Russian state and thereby indirectly supporting the Russian regime and so forth. So there are very interesting topics that maybe haven't discussed in detail yet, also discussed in this particular resource. So this might be something to look up in the future.
I'm not going to answer the questions. Let me highlight just that I think several people here mentioned regulation. I understand regulation is important, but it does not substitute market forces. And we have evidence that consumers react by changing their choices when they see bad news, negative news about the sustainability practice or the ESG practices of a given company. And that can also be a powerful force. Investors, as I mentioned, can also be a powerful force of change, positive change. And finally, workers. And we also have evidence that especially younger generations are willing to give up salary to work for companies that have better ESG practices. And these market forces can be as important as regulations in terms of driving change.
Cannelle, just 36 seconds.
Yeah, on the question on stakeholders and engagement, I also wanted to add that there is something that's called, so for indigenous people, something called the right called free, prior and informed consent. And I have seen very local but still hopeful initiatives of indigenous communities in Latin America actually reaching out to companies at the beginning of the project in order to include in free, prior and informed consent and approval of a project, let's say a mine, already conditions of disengagement in case there is already a conflict that is latent, and how would the communities but also workers want to be treated and compensated as part of this process of disengagement. So disengagement can be planned during the engagement, basically.
We are 15 minutes late. Thanks so much, and we have to close now. Please join me in thanking our speakers and the audience, both here in person and online. And we will now move to the coffee break that is waiting outside. Thank you.